Good morning, sir. I am Rafael and this is my final oral examination. So, question number 1. Who must prosecute criminal actions under latest amendments to Section 5, Rule 110? All criminal actions commenced by uncompliant or information shall be prosecuted under the direction and control of the prosecutor. Question number 2. When is complaint or information deemed sufficient? State the name of the accused, the designation of the offense given if the institute, the act of the omission complaint or the constituting of the offense, the name of the offended party, the approximate date of the commission of the offense, the place where the offense committed. Question number 3. What are the elements of a prejudicial question? The elements of the prejudicial question are previously instituted civil action involves an issue similar or intimately related to the issue raised in a subsequent criminal action, and the resolution issue determine whether or not the criminal actions may proceed. Question number 4. Define preliminary investigation and when is it required? Preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to engender well-founded belief that the crime has been committed and respondent is probably guilty thereof and should held for trial except as provided in Section 7 of this rule. Preliminary investigation is required to be conducted before the filing of a complaint or information for an offense of a penalty prescribed by law, 4 years, 2 months, 1 day, without regard to the fine. Question number 5. What is inquest investigation? Under Section 7, Rule 112, when a person is lawfully arrested without a warrant involving an offense which requests a preliminary investigation, the complaint or the complaint or information may be filed by a prosecutor with need of such investigation provided inquest that has been conducted in accordance with the existing rules. Question number 6. Define arrest. How is it made? Arrest is the taking a person into custody in order that he may be bound to answer for commission an offense. An arrest is may be actual restraint or a restraint of a person to be arrested or by submission to the custody of the person making the arrest. Question number 7. What are the instances when arrest without a warrant is lawful? A. When his presence to be arrested has committed, is actually committing, or is attempting to commit an offense. B. When an offense has just been committed or he has probable cause to believe, based on his personal knowledge and facts, and when the person to be arrested is a prisoner who escaped from Question number 8. What is bail? What are the kinds of bail? Bail is the security given for a release of a person in a custody of law, furnish him or a bondsman to guarantee his appearance before any court as required under the condition and of other after specified. Bail is given the form of corporate surety, property bond, cash deposit, and recognizance. Question number 9. Give at least 5 rights of the accused. 1. Presume innocent until contrary is proved beyond reasonable doubt. 2. To be informed the nature of the cause of the accusations against him. Number 3. To be exempt from being compelled to be a witness against himself. Number 4. To speed impartial and public trial. Number 5. To appeal in all cases and in all criminal and in a manner prescribed by law. Question number 10. How is arraignment made? A. The accused must be arraigned before the court, the complaint or information has filed or assigned for trial. B. The accused must be present at the arraignment and must personally enter his plea. C. The accused refused to plead or makes conditional plea, a plea of not guilty shall be entered for him. D. When the accused pleads guilty but present exculpatory and exculpatory evidence and a plea of not guilty shall be entered for him. E. When the accused is under preventive detention, his case shall rappelled and its record transmitted to the judge, to whom the case was rappelled within 3 days from the filing of the information or complaint. F. The private offended party shall be required to appear at the arraignment for purposes of plea bargaining, determination of crime, of civil liability, and other matters requiring his presence. G. Unless a shorter period is provided by special law. Question number 11. What is plea bargaining? Plea bargaining is the disposition of criminal charges by agreement between prosecution in a criminal case where out of mutually unsatisfactory disposition or at the case subject to court approval. Question number 12. What are the instances when arraignment may be suspended? Upon motion by the proper party, the arraignment shall be suspended in the following cases. A. The accused appear to suffering from unsound mental condition. B. There exists prejudicial question. And letter C. A petition for reviews of the resolution of the prosecutor is pending at either at the Department of Justice. Question number 13. When does double jeopardy attaches? When the accused has been convicted or acquitted of the case against him deemed or otherwise terminate without his express consent by a court of competent and jurisdiction. Question number 14. What is the order of trial in criminal cases? A. Prosecution shall present evidence to prove the charge and the proper case, the civil liability. B. The accused may present the evidence to prove his defense and damages. C. The prosecution and the defense may in that order present rebuttal and show rebuttal evidence. D. Upon admission of evidence of the parties, the case shall be deemed submitted for decision. E. The accused commits the act or omission charge of the complaint. Question number 15. When a co-accused be discharged to become a snake witness. When 2 or more persons are jointly charged with the commission of any offense upon motion of the prosecution, before restrains the accused to be discharged with their consent may be witness for their states. 16. Define judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and imposition on him on a proper penalty and civil liability. Number 17. Define search warrant. Search warrant is an order written issued in the name of the people of the Philippines, signed by the judge and directed to a peace officer commanding him to search for personal property described therein and bring it before the court. Question number 18. What are the requisites in order that a search warrant be issued? A search warrant shall not issued except upon probable cause in connection with the specific offense to be determined personally by the judge after examination under oath or affirmation of a complaint and the witnesses. He produced particularly describing the search and things to be seized, which may be were found anywhere in the Philippines. Number 19. What are the personal property subject of search and seizure? Search warrant may be issued for the search and seizure of personal property. A. Subject of the offense. B. Stolen or embezzled and other footage of fruits of the offense. And C. Used or intended to be used as the means of in committing the offense. Question number 20. What are the qualifications of a witness? All persons who can perceive and perceiving can make known their perception to others may be witness. Religious or political belief, interest, and outcome that case or conviction of a crime unless otherwise provided by law shall not the ground for disqualification.